Good evening. Hi, my name is Jill Witkowski Heaps. I'm an attorney with Earth Justice. If you're not familiar with Earth Justice, we are the nation's premier nonprofit public interest environmental organization. I have been working on National Environmental Policy Act or NEPA cases for 17 years. I won my first case 15 years ago. And won it again 4 years later because they came back with the same project and had other issues with it. Today I'm going to give you a quick background on NEPA, the National Environmental Policy Act, how it relates to this project, and specifically touching on what is an environmental assessment, what is a categorical exclusion, and how does this, how do these differences impact public input. I'm going to share my screen. If for some reason I'm having technical difficulties, if one of the presenters could just unmute and tell me I'm having problems, that would be great. Okay, today's topic is how the law can facilitate or prevent public input in highway projects. For those of you unfamiliar with the National Environmental Policy Act, it is our premier environmental law and the nation's first environmental law. And it's primarily a sunshine law, which is shedding light on a proposed federal project. It applies to major federal projects, not state projects alone. And the basic idea behind NEPA is to understand environmental and human impacts of a project before resources are committed or before the project is started. And it's basically a look before you leap statute. It says you could pretty much make a dumb decision, but you gotta let the public know what your decision is before you make it. So how does NEPA work? The main idea behind NEPA is looking to see if the project is going to have significant impacts, particularly significant environmental impacts. If we know from the get-go that this is a huge, huge project that will have significant environmental impacts, the agency will start with an environmental impact statement. These can be thousands upon thousands of pages long, record of decision with multiple appendices. Many highway projects actually use an environmental impact statement. There's one project in Syracuse right now where they're looking to remove the elevated portion of highway Interstate 81 and put it at road level. And they are using, New York DOT is using an environmental impact statement in that process. When an environmental impact statement is put together, an important part is that there is formal notice and comment. That means that the draft documents are put out to the public. The public has an opportunity to review and comment on it, basically making sure that the decisions are not arbitrary and capricious, and making sure that the decisions basically make sense and that all the environmental impacts have been studied. If we're not sure if a project is going to have significant impacts, but probably won't have significant impacts, the law requires an environmental assessment. Now, an environmental assessment is often called, was initially called a quick and dirty study of a project. And while environmental assessment many years ago used to only be 40 or 50 pages long, these days environmental assessments can be hundreds of pages as well. An important thing about environmental assessment is that the project applicant needs to identify the project purpose and the need. So in this case, if we're identifying the project purpose, is it the project really to help reduce accidents and to increase pedestrian accessibility to the bayfront? And what's the need for that? And then you would look at alternatives and really seeing which alternative actually meets the project purpose and need. So in our case, here, if you have an alternative where you're actually building a highway, but you're claiming your purpose is to increase pedestrian access, you may have a problem here where your selected alternative doesn't meet your purpose, project, and need. In other cases, we've seen projects that has a project purpose that's defined so narrowly that only one alternative could possibly work. But the point of an environmental assessment is to bring the project and the need and the alternatives to light and to bring public input to these. And also important here is a comprehensive look at environmental impacts. For example, in this case, we would look at stormwater impacts. If you're going to build a highway, are you going to have more stormwater runoff? Are you going to be creating more stormwater runoff in impaired waterways that are on either end of the Bayfront Parkway? And also, with an environmental assessment, an agency has a duty to comply with Executive Order 12898, which is about environmental justice, and actually taking a hard look to see how the project would impact environmental justice communities and neighborhoods. If the environmental assessment reveals that there are significant impacts to the project, the agency will do an environmental impact statement. But often, instead, they come to a different conclusion. They do formal notice and comment, and then they do hey, we got a FONSI, finding of no significant impact, which basically means they've done all the analysis and we don't find any significant impact here. The other option is a mitigated FONSI. If there are potential significant impacts, but the agency can commit to mitigation measures that will make those impacts less than significant, they will issue a mitigated FONSI. There are requirements for formal notice and comment before an agency issues a FONSI or a mitigated FONSI that may or may not include a public hearing. But in either way, both an environmental assessment and environmental impact statement involve significant paperwork and significant formal opportunities for the public to be involved. Because of industry pressure, this council, CEQ, the White House Council of Environmental Quality, said, hey, if we really know that this is the type of project that we know will not have significant impacts, we can issue a categorical exclusion. These are supposed to be for particular categories of projects like road resurfacing. And the idea behind the regulations is we list 20 or 30 different kinds of projects that we know through our experience will not have environmental impacts. And then we go through a process where we show that this categorical exclusion applies. The tricky thing about this, formal notice and comment, no. Basically, once a categorical exclusion applies, there is no requirement for formal notice and comment, and basically the agency can go forward with their project without having to formally involve the public. What seems to be strange here is that PennDOT basically started an environmental assessment and then said, hey, looks like we're not going to have any environmental impacts, so let's try to get a categorical exclusion. Except if you see from the process here that's supposed to take place, the outcome of an environmental assessment usually is finding of no significant impact. So what they're doing is they were having the same outcome, right? No significant impact, but they've skipped this whole formal notice and comment period, which is why if there's any possible way for us to get into the environmental assessment or environmental impact statement land, that's where we would want to be from a public input standpoint.